taken by the EU institutions. But the limits of that were demonstrated in the Connolly case. Mr. Connolly was a man who was employed by the Commission and made redundant, and he brought a challenge before the EU courts. And when the Advocate General, this all went to appeal and was before the CJEU, the Advocate General gave his or her opinion, and Mr. Connolly complained that the procedure in Luxembourg didn't allow him to make observations or make submissions on the opinion, and that was contrary to Article 6 of the Convention. And he tried to bring his claim in Strasbourg based on Article 6, and that was rejected. He brought the claim against all 15 member states because, of course, the European Court of Justice could not be a respondent. But that was rejected on the basis that essentially the member states were not sufficiently involved, and this properly looked at was a challenge against the EU itself, which was not admissible. So, of course, post-accession, that will all change, and people will be able to challenge EU legislation or measures directly, and indeed will be able to challenge judgments of the European Court directly. Of course, the general rule in Strasbourg is that domestic remedies have to be exhausted first, and I assume the same will apply on accession. But exactly how it applies will, I guess, be dealt with in the rules. But it seems to me what that means is that in relation to direct challenges, so direct challenges to community measures before the European courts, then you would have to exhaust your remedies before the European courts first before going to Strasbourg. In relation to indirect challenges, you'd have to first of all exhaust your remedies in the national court. So if you don't have standing to bring a challenge in Luxembourg, you would have to indirectly challenge in the national courts. Now, of course, if you're challenging validity of legislation, there has to be a reference to the CJU under the photo frost principle, because national courts can't declare community legislation to be invalid. Only the CJU can do that. So the CJU will be given the opportunity on the reference to pontificate on the compatibility of the EU legislation, piece of EU legislation with the Convention. But then again, if the individual doesn't like the answer, then they'll be able to go to the Strasbourg court, which is what I meant by a further tier of review. That will, I think, bring a certain degree, accession will bring a certain degree of coherence to multi-targeted challenges. Now, what do I mean by that? What I mean by that is that very often when you're invoking, when you're invoking EU law in national courts, very often the situation is this, that there is some underlying piece of EU legislation and some type of national implementation or implementation of the EU legislation by a public body or a national body, and that the individual will generally be challenging both, or challenging or making submissions on the interpretation of both. And at the moment, there's a very odd position where if you're bringing, for example, a challenge in the English courts to a national measure which implements an EU measure, and you want to bring both measures into the frame, then in relation to the national measure, you can argue that that breaches the Convention on Human Rights under the Human Rights Act. But in relation to the EU measure, you can't, and you have to argue your case on the basis of the Charter. Now, that might not make a difference in practice depending on the right that you're invoking, but what it does mean is that when the EU exceeds, then you'll be able to rely on the Convention in relation to both parts of the challenge, which I think will be a bit more coherent. Impact on case law. Now, the EU courts, as Steve said, already purport to take account of, to apply the Strasbourg jurisprudence, but I think it's a bit hit and miss, and that they're not always particularly analytical or particularly methodical about doing that. And I think that convergence will speed up because there'll be a very strong incentive for the European Court to apply the Strasbourg case law properly, because if they get it wrong, then the Strasbourg Court will be able to say so. I note on the slides that there's also, interestingly, been a reverse effect, and by that what I mean is that the Strasbourg Court is more and more taking account of EU ECJ interpretation of human rights provisions. And the Cardi and Nada judgments are quite interesting examples of that, because these are both in the context of asset freezing. And in the Cardi case, and that line of cases, the ECJ has been pretty forward in applying human rights to ensure that the institutions are acting properly and according to a fair procedure when putting people on these lists, which mean that their assets get frozen, these sanctions cases. And in Cardi, the European Court of Justice said that the fact that underlying all of these acts is a UN instrument doesn't matter. So that doesn't immunise the actions of the European Council. They still have to be compatible with human rights. And the Strasbourg Court used to take a much more hands-off approach and did used to defer in practice to UN measures, to the UN. And then in the NADA case, it suddenly became a lot more rigorous itself and referred to the ECJ's judgment in Cardi and properly scrutinised a UN measure for the first time. So there's a kind of reverse effect, and that will probably speed up too. Now, effect on the English courts. I think that there are so many different permutations, but I thought what I would do is just try and illustrate some of the issues that might arise by reference to a real-life case or several connected real-life cases. And these concern returns of asylum seekers under the Dublin II regulation. Now, the Dublin II regulation sets up a system for allocating responsibility between member states for determining asylum claims. And generally, the responsible state is the first member state that the asylum seeker arrives at when they enter the European Union. But sometimes asylum seekers go from one member state to another, and perhaps even a third. And the second or third member state are permitted under the Dublin II regulation to return the asylum seeker to the first member state because that's the responsible state. But there is a discretion not to do so and to determine the claim themselves. Now, as you can imagine, member states are not exactly rushing to exercise that discretion. But the question in these cases are, in which circumstances are they compelled by the ECHR to exercise the discretion to decide claims themselves? And the MSS case against Belgium and Greece raised exactly that point. So this was an asylum seeker who arrived initially in Greece, which was the responsible state, and went to Belgium. The Belgians wanted to transfer him back to Greece, and the question before the Strasbourg court was whether that would be compatible with his rights under Article 3 of the ECHR. And the court held that it would not be, because the conditions that he would meet in Greece, the reception conditions for asylum seekers, would give rise to a real risk of a breach of his Article 3 rights. And so it applied the Suring test, its long-standing jurisprudence, and held that therefore transfer would be inadmissible. Now, at the same time, or just afterwards, the ECJ was busy looking at a similar case, the NS case. That concerned an Afghan national who again went to Greece and then came on to the United Kingdom. And the question was whether the UK had to exercise its discretion to determine his asylum claim, or whether they could return him to Greece. And the issue here was a question of interpretation of the Dublin II regulation and whether his return would breach Article 4 of the EU Charter of Fundamental Rights, which is the provision analogous to Article 3. And what the ECJ said was that there was a duty on member states not to return an asylum seeker to the responsible state if there existed a systemic deficiency, and those are the kind of key words that have been picked up on in later cases, a systemic deficiency in the asylum procedure and in the reception conditions of asylum seekers in the responsible state. Now, is the existence of systemic deficiencies a necessary requirement? And this came before the English courts in the EM Eritrea case, a case which for once didn't involve Greece but concerned Italy. So the Court of Appeal said that the existence of systemic deficiencies is a necessary requirement because that's the proper interpretation of the CJU's judgment in NS. But the Court of Appeal said, well, hang on though, that's inconsistent with the Strasbourg-Suring test, because the Strasbourg test just asks whether there's a real risk of a breach of a person's Article 3 rights. And you can demonstrate that on the basis of whatever evidence you like. You don't have to show that there's some kind of systemic deficiency. But the Court of Appeal said, well, all right, it's inconsistent with Strasbourg, which we don't like, but the English courts have to apply the CJU's ruling because under Section 2 of the European Communities Act, we're bound to apply that, whereas we're not bound to apply the Strasbourg jurisprudence. Now, this all came up before the Supreme Court, who reached a sort of compromise solution. So they said that they looked at the CJU's judgment again and they said, well, actually, on a proper interpretation, it doesn't elevate systemic deficiencies into a necessary requirement. So everything's fine and dandy and we can comply with NS, and that's not inconsistent with Söring. But the sting in the tail is that just after that, the CJU gave another of these judgments in a case called Abdullahi, and said in terms the only way in which the applicant for asylum can call into question the jurisdiction of the responsible state is by pleading systemic deficiencies in the asylum procedure and in the conditions for the reception of applicants for asylum in that state. So in other words, the Supreme Court has got it wrong. The way that they interpreted NS was too generous to the CJU, and the CJU seems to be applying a test which is inconsistent with what Strasbourg has said. So where does that leave the court? Well, I think it leaves the English court was addressed by the Court of Appeal, so that the English court said, well, this is inconsistent with Strasbourg, but we have to apply the CJU jurisprudence. But the interesting question and the complicated question is where would that leave the English courts if all of this took place post-accession? Because post-accession, things would be different, because although the English courts would be bound by the CJU's interpretation of Article 3 of the Convention, the CJU's interpretation is itself subject to further review before the Strasbourg courts. So what would the English courts do? Now, I think that's an exam question if ever I've seen one, but I think that what the English courts would inevitably do is refer the question to Luxembourg. I think the pragmatic solution would be that the English courts would refer the question to Luxembourg, pointing out its view of the discrepancy between the Strasbourg and Luxembourg test. The Luxembourg court would rule as it sees fit, and if it wasn't in the claimant's favour, the claimant would be able to bring a claim in the Strasbourg court after that. So I hope that demonstrates some of the issues that might arise post-accession from the point of view of practitioners and individuals. Thank you very much for listening.
Thank you very much indeed. Now it's the audience's turn to pose questions to our speakers. You are not confined to asking them about things they said. Do feel free to ask them about anything else about EU accession to the ECHR that is a burning issue in your mind. I can't guarantee that they will answer you beyond the content of what they've already said, but I'm sure they will all charmingly endeavour to. Ralph? Could you please identify yourself? And I'm going to repeat your question because you're not on a microphone and this is being recorded, and I'm repeating your question so that it gets recorded. It's not because I'm trying to rephrase what you have said. Thank you.
I think you might be able to guess what my question would be. My name is Ralph Wild. I'm an academic at UCL. In the light of the Strasbourg case law on the extraterritorial application of the Convention to states, do any of the panelists and maybe even the chair have any thoughts about the implications for EU external relations, for example, sanctions, development assistance, Frontex, of the Union ratifying the Convention?
I wasn't writing all that down, so you'll have to correct me if I don't repeat it correctly. What do we think about the extraterritorial application of the ECHR in the context of EU activities, given the Strasbourg jurisprudence on the extraterritorial application of the ECHR? Is that more or less what you asked? Thank you.
Shall I?
Please, Steve.
Well, that's a great question, isn't it? I think that, subject to the possibility of the EU making a reservation to the convention, which is something it can do. I don't think we've mentioned it yet, but I don't know if it will do, but it can do. Subject to that possibility, everything in the convention should have the same effect on the EU that it has on the member states. It's not signing up to all the protocols, as Tim mentioned, so subject to that qualification as well. But in the main ECHR, the protocols it's signing up to, there's no reason to think that the ECHR has any different impact on the EU than it does on the member states substantively. The issue that does arise, of course, is there a link to EU law? Subject to those questions I raised about whether the Court of Justice might have jurisdiction beyond cases where there's a link to EU law and the ECHR. But certainly the ECHR will apply where there's a link to EU law, whatever exactly that means. And to look at the examples you gave, of course, sanctions I wouldn't even describe as extraterritorial because they're mainly directed at people and organisations on the territory of the European Union. They might have an impact, I suppose, on transfers from abroad, but as such, they don't purport to tell the Iranian banks what to do, courts what to do in Iran, or as such. So, but yeah, there's no reason that they wouldn't apply to sanctions. Development assistance, again, you could obviously it's spent elsewhere, but the decisions to spend the money are made by the EU institutions or perhaps by member states implementing EU rules, and so therefore I don't see a problem applying the ECHR in that context. Frontex and also what I would add to that, national border control operations outside their territorial waters, and collaboration with third states outside their territorial waters. I think those aspects do fall within the scope of EU law, and anything the EU agency does is within the scope of EU law, and anything member states do to control the external borders of the European Union, even it seems outside their territorial waters, according to the ECHR itself in the Hersey-Jama judgment, when the EU's Home Affairs Commission made a concession on this, that falls within the scope of EU law, and so you can bring challenges to cases like Hersey or in cases like Sharifi in Italy, where people moving between member states, and the Dublin regime was challenged again. The Human Rights Court recently said Italy cannot stop people coming from Greece across the Adriatic and send them back, because people must be allowed to escape the Dublin system if it results in their inhuman treatment in Greece. And I would add to that one you didn't mention, the common foreign and security policy. When in principle, the Court of Justice has no jurisdiction, but of course it's part of EU law. So there's a very interesting question when the EU signs up to the ECHR as to whether the ECHR might have some jurisdiction over foreign policy in a way which the EU does not. And so the EU's operations abroad, if there's some questions about whether their violence is impermissible or involved in some kind of abuse that would violate the ECHR, the question will arise, do you apply the standards of the ECHR and the jurisprudence on when armed forces acting abroad are covered by the ECHR? Sometimes yes, sometimes no. Do you apply that in the same way to the CFSP, even though the Court of Justice has no jurisdiction over it? And I think logically you would. But although I think this has been raised in the hearing before the Court of Justice. So we may have an answer to that on December the 18th, or the beginnings of a hint of an answer.
Thank you, Steve. Tim?
I'm not going to answer the question, but I mean, if there were to be a model answer...
I warned you they might not answer that.
But if there were to be a model answer, perhaps I can just observe on a couple of things you would expect to find in it. For all, I'm not going to say what the answer on each of them would be. I mean, and to take some of Steve's points, I mean, isn't extraterritorial jurisdiction or extraterritoriality going to be the issue of the next 20 years? But let's go back to some of the building blocks about the limits of of competence, shall we? Because, I mean, there's a key issue that the treaties preclude accession conferring additional competence on the EU. Now, I'd say little more than that other than to observe on it, but to observe too that the there's ECJ case law on the reach of EU law geographically, and let's limit ourselves to that for the moment. And there's a question there, isn't there, about the relationship between what the Strasbourg Court has said, and increasingly frequently on extraterritorial reach of the Convention on the one hand, and what the ECJ has said about the reach of EU law on the other. I'm not sure that they necessarily fit terribly happily together. But of course, then you get sort of oddities coming out of strange places. Google, anyone who's a data protection nerd, I spend my life keeping data protection in its place, but it's worth a look. Look at the Google judgment, Google Spain judgment, which is quite an interesting series of conclusions. I mean, about how far EU law can reach, and in a rather different sort of frame of reference. But if for those interested to do the master's thesis on it rather than the one-off exam answer, compare and contrast with what the Advocate General said in that case as well. So yeah, tricky stuff. But my starting point naturally is what the treaty says about the limits of competence and how far the accession agreement can't go in conferring it. And as Steve said, CFSP did very much come up at the hearing and is certainly going to feature. Whether the court answers it will be an interesting question.
Do you want to add something to that?
Just very briefly, which is to say that I guess there's a distinction between what's the reach of EU law, and Tim's absolutely right, which is that the competencies of the Union can't be changed by accession. But then separate question, I think distinct question is, well, whatever the reach, are these matters which are within the reach? So let's assume what you're within the reach, are they justiciable? And there's a whole range of matters which are not justiciable before the Luxembourg Court. And I think a very interesting question is, will they be justiciable before the Strasbourg Court? Because if they are, then however many sort of references sideways or whatever you have, that won't work. It will be the Strasbourg Court looking at these things in circumstances where the Luxembourg Court can't. So just wanted to add that.
Could I add just quickly to the point about Google? I mean, in the summer, an Irish court sent a case to the Court of Justice called Europe versus Facebook, which is precisely about what happens in the United States to data when Facebook processes it, because the NSA allegedly gets access to it, after which we now know from the Snowden revelations. And then this week, the European Parliament has decided to ask the Court of Justice about a draft passenger name records treaty between the EU and Canada. And basically the question there is, do the Canadians have good enough standards? And that's, I think, a disguised way of questioning whether the Americans and Australians, where we already have treaties, have good enough standards, whether the American deal with the EU in relation to bank transfer data has good enough standards as well. So it's calling into question things which haven't even been challenged. The European Parliament could have blocked them at the time, and now the majority maybe regrets that they didn't, and is using this as a way to challenge that. So those are definitely both extraterritorial issues, and if the Court of Justice is going to start defining extraterritorial limits to the scope of EU law, perhaps these are the cases, because otherwise it will have to shut down Facebook if you take the data protection and all other social networks originating from the United States, which is most of them, if you take data protection more seriously.
Thanks, Steve. The gentleman over there and one over here.
Alex Haynes from Bretton Woods Law. What about international governmental organisations other than the EU, specifically organisations based in the UK, for example, the European Bank for Reconstruction or the Commonwealth Secretariat? Does the panel see a trend for organisations, international organisations, signing up to the convention? And I ask that question because lawyers for international organisations have a habit of disputing the fact that they may be bound by, for example, customary international human rights principles. And I wonder if this move might influence other organisations, perhaps not the smaller ones, but the bigger ones, for example, the multinational development banks, into signing up for this convention.
Thank you. Again, I'll try to summarise. The gist of your question was, what does the panel think about the increasing trend for international organisations to sign up to international human rights standards, and what do you think the likelihood is of the EBRD or the Commonwealth Secretariat or other similar international bodies based in the UK of asking to adhere to the ECHR, and what do you think would happen if they did make such a request? Was that what you asked? Thank you.
Well, I mean, I think that's quite a political question, but I would just observe, as from a lawyer's point of view, that it's not necessarily a straightforward thing to sign up to the convention, because, as Tim explained, there needs to be special provision from the Council of Europe's perspective. There had to be special provision even for the EU to accede, and the EU is in a very particular position because it comprises its members are member states which are all signatories to the convention, and there are particularly compelling reasons for the EU to accede which don't necessarily extend to other organisations. So if it's hard, if Tim and others are finding it hard to make this work, I think it would be even harder logistically for other organisations to accede. But I can't claim to have any particular expertise on that question. That's just the observation that occurs to me.
Thank you. Does either of the others want to add to that?
Well, I'm obviously looking at the process from the outside of the EU accession, but it did, even from the outside, it looked like an intensely painful and difficult process. I don't know, it was how it was quite like inside, and I can't imagine Strasbourg being in too much of a rush to reproduce it, even though it should be easier with other international organisations. I can't imagine it being really too high on the agenda.
I mean, I keep suggesting that what the